Hello, and welcome to another exciting episode of the Conscious Counsel podcast with your host, Corey Sterling. What's up? That's me. I'm so excited that we get this opportunity to hang out and be together. As always, I value it, and I appreciate that you're here. This episode is a juicy one. This is an exciting one. I had this one on my list for a while, and I'm really excited that this moment is the time that I get to address it. So before I hop into this week's topic and what we're going to talk about, I just want to remind you that the intention and the purpose for these episodes in the Conscious Counsel podcast is to help you protect and grow your wellness business with confidence and clarity. It's my mission. That's why I'm here. I want to share the information that I have. I want to reflect on the experiences I've gone through with my clients to help you out and make sure that you're taken care of and that you're doing things properly. So without any further ado, this week's topic is called Avoiding Partnership Pitfalls. Dun, dun, dun. I definitely need an editor for this podcast to put in the dramatic organ music. Dun, dun, dun. Partnership pitfalls are a real thing. It's something that I've seen a lot of in my legal practice and my time as a lawyer, and I'm excited to dive into some of the legal elements to it, but also this is really just a practical relationship sort of podcast and reflections on what make the best relationships in a commercial sense and how to have that supported legally. So the reason why this matters to you is because a lot of you out there are operating a business with a business partner, or you're doing some form of joint venture where you're working with someone else on something. I mean, those are very vague words, working with someone else on something, but it is very, very real, and there's often a lot at stake. And what always boggles my mind is that people will spend so much time and money and energy on a business and business cards and clothes and paying rent and all of the upfront costs of running a business and put their whole life and spend countless hours on it and not set things up properly from the start. And it sort of breaks my heart. That's the Scottish accent. It breaks my heart. It does, eh? That's brilliant. That's really, really tough. And I think that the biggest one of what comes to is business structure and relationships in partnership. So the reason why this matters to you is that if you have an existing business or a joint venture that you're currently in without the right documentation for the relationship, then listen up, because there's some really, really important information that you need to know. And the truth is, no one else is going to tell you this, but I'm just going to, truth talk you. Your business depends on it. Your livelihood depends on it. I wouldn't say your happiness depends on it, because you can still be happy even if things go terribly wrong, but just make your life a lot easier by thinking about these things and putting them into action. As always, I'm going to share a story. And when it comes to partnership pitfalls, I got a lot of stories. I'm just going to choose one today, but I have a lot of them. Okay, so let's dig in. Now, the thing to know is that if you are operating, where does this apply? The first question is who does this apply to? And this will apply in a situation where either there's a project that two people are working together on, or it's going to apply to a company and the ownership of that company. So most of the problems that I have to deal with are when it comes to an LLC or a company or a corporation that has multiple owners, but never took the time to put the proper documentation into place. And trust me, I know what it's like at the start. At the start, you're super excited. All you want to do is jump in and start the business. And I love this person, and they're my best friend, and everything's going to be perfect, and we're going to do such a great job. And I love all of that. I love that for you. I want that for you. But also, things can go south. People can change. What people want can change. Accidents can happen. Everything, all of the variables are in play. And that's why, because there's so much at stake, in this case, your business, it's so important to do everything properly from the start. And so when it comes to ownership of a company and multiple owners, in Canada with a company, there's a document that's called a shareholder agreement. And in the United States, for an LLC, there's something that's called an operating agreement. And the purpose of both of these documents is to outline all of the rules of ownership as it relates to the company. And there's a lot of different things that you can put in there, and I'll talk about a couple of them. But in essence, what you need to know, there's a document that says, hey, we're starting this company, and this is what the intention of the owners is as it relates to navigating the business, navigating financial contributions, navigating payouts, navigating responsibility, all of those sorts of things. When it's in a personal sense and it's not related to ownership of a company, but maybe two people working together on a project, you can have something called a collaboration agreement, or you can have something called a management agreement, which would be like, okay, we're working on this thing. This is what everyone's responsible. Now, just to take things back a little bit, I haven't been able to say the word legal position in a while, but in this case, what's really, really relevant and why this matters is think about where you are now, and then think about a time in the future, like 6 to 8 months or 2 years, where a problem comes up as it relates to the business. One person wants to expand, one person wants to shut down, one person wants to bring someone in and bring in other owners, one person wants to sell their amounts. One person thinks that the owner should be getting paid more. One person thinks more money should be invested in the business. All of these things, look, if you're in a partnership, it's quite likely you're going to come up with any of those issues that I've listed. And the purpose of having either an operating agreement or a shareholder agreement is that you decide in the present moment how you will behave and what rules you'll have to follow in the future. So it's not going to be about who's right and who's wrong and who did this. But in the event that there's a problem that needs to be resolved, you're going to use this document to resolve the problem. So let's say someone makes a bid to purchase the company, or someone wants to buy it. It's not like, oh, I feel like this, but this person feels like this. It's no, the corporation, the LLC, has to behave in a certain way. And if an offer is made to purchase the business, these are the rules that we will follow. A, B, C, D, E, F. All of it's outlined. Let's say one person is not contributing financially, or one person has contributed a lot more financially, and that person hasn't paid the amount back that they're supposed to. The agreement will say, in the event that the principal amount is not paid back, A, B, C, D, E, F. And like I always say when it comes to law, it's all about communicating expectations openly and honestly. And really why this document is so relevant and so important is because this is going to determine how you resolve problems for ownership of the business. And again, just think about how much time you spend on marketing, on HR, on actually providing your services, on building, on growing, on meetings, on improving, on everything. And this is the core document about the ownership of the business that matters so much. So the most common mistake that I'll see happen, and it's actually happened less for me since my legal practice has grown. I think because I've spoken out about this so much, and I've kicked up so much dirt letting people know that they need these things done from the start. In the first half of my legal career, it was very, very often that I would get people who were already operating their business. I didn't get a chance to start with them at the beginning and set them up with documentation or put them in a position to succeed. But they would come to me when there would be a problem around the ownership. And like always, I always ask the same question. I would say, please send me a copy of the signed operating agreement between the members. Or I would say, please send me a copy of the shareholder agreement. Or I would say, please send me a copy of the management agreement outlining everyone's responsibilities for the project. And the worst answer that I get is when people say, we don't have one. That's my email voice. Like I read email in that voice. Like, sorry, we never got one. And I'm just like, okay, this is tough. So what I'll brief, and when I've been in those situations and I've had to resolve those problems, it is very, very, very difficult. So you want to have these agreements in place. And if you don't have these agreements in place, it will be very, very difficult, especially if there's a contentious issue or problem or some adversarial issue has arisen between owners. It's very, very difficult to resolve it without having a document that outlines the process that should be followed. Now, I'm going to tell you a story And actually, before I tell you the story, I want to explain normally what sort of provisions will be included in this agreement. And I've touched on it generally. I just want to be a little bit more specific. So generally, the point of having an ownership agreement is that it outlines who's doing what happens if someone wants to sell, what if someone gets hit by a bus, what obligations someone has towards the business or the company, how much we're getting paid, what the dividend payouts are. If someone has put more capital up at front, do they get paid preferentially? Do we want to bring on other investors? What happens if someone else wants to join? All these sorts of questions and things are just dealt with in the agreement proactively. Now, the story that I'll tell, and again, I do have a lot, and it's actually all the same story, but this was earlier on in my career. Two women started a very, very successful business, a multi-7-figure business. So they're really good at business. They're really good at sales. They're really good at what they do. And they triggered each other quite a bit. And it was actually my first foray into mediation. I almost said the word meditation because I love meditation so much. It was like coming up in my mind. I'm like, no, mediation. And I worked with them what happened was they had a 7-figure business that they each had a very different vision about where it should go and what they should do with it. And they had no signed operating agreement. So when there's no signed operating agreement or there's no shareholder agreement, the rules that will apply will be the business corporate law rules for the jurisdiction. So the government has already contemplated what happens if there's not an agreement that outlines the roles and the responsibilities. And they say, cool, if there's no signed agreement, these are the general rules that are going to apply to the relationship of the company. But I can tell you they don't help anyone. And it's very, very difficult for people who already aren't getting along and are triggering each other. They don't want to go through through the process of following the general rules that's included by the corporation law for the jurisdiction. So it was a lose-lose outcome if they weren't able to come to an agreement. They didn't have a document that outlined who can do what and what they should do and how they can take the direction of the company and who can make an offer to buy the other person out. None of that spoken. So I just basically had to mediate for them and sit and have meetings. And there's a lot of things that I love about my legal practice, but I can tell you, spending 3 days with two people who just trigger each other and fight a lot, and me trying to keep the peace. I did have a lot of yerba mate with me, so I was sipping my mate, but it's not what I'm put on earth to do. And it's also just like, it's awful. It's terrible when people fight and cry and scream, and all of it could be so easily taken care of and avoided if everything was just organized beforehand. And the key issues for them was what direction they wanted to take the business, how the funds would be allocated. One person wanted to reinvest everything back into the business. One person wanted to take a payout. And then I'm just sort of trying to help them navigate it. In the end, we were able to come to a settlement agreement, but they paid me tens of thousands of dollars to help them, plus the agreement. But even worse, it's just like, it's a fractured relationship. And it's two people who are so talented and who did such a great job and were such talented business owners. And if they had this one document, the whole problem would have been taken care of. And so in the end, it cost them a lot more, like everything, the pay me now, pay me later story. When it comes to law, you can do everything properly, proactively, securely upfront, or you can let it go and not address it and just be more comfortable not talking about the elephant in the room, and then the elephant's going to squash the room, and then we have to pick up the pieces. But this was just a really, really classic example of, okay, not a question if they're a good business owner or not. The parties own the business together. They haven't spoken about the expectations as it relates to the core functions of the business and the responsibilities of each owner, and what direction the newest iteration of the business should go in. And so I just call it the Wild West. It's the Wild West because you have to find a way to come to an agreement. Nobody wants to use the basic corporate laws that say, in the event that there's no operating agreement, we will apply these general laws, which don't help and don't fit anyone. And in this case, it was very, very costly. And ultimately, the relationship between the parties was lost, which made me really, really sad. So all of that being said, just a bit of a summary about this topic of law and what's relevant and what you need to know. Communicate expectations openly and honestly, get it in writing, think about what you're going to want in the future for the business, and put that down at the start. And it doesn't have to be perfect. You don't have to get it first shot out of the cannon. Okay, amazing, we understand everything. No, let's start. Okay, we can revisit, and I do have a lot of clients who revisit their operating agreement every year. Once a year, they'll revisit it and they'll look at it and they'll refine it and they'll tune it. But the big thing is the way that you avoid the partnership pitfalls is you put something in writing that reflects the expectations you have in the relationship, and B, you make sure that when you do that, you're freaking honest with each other. This is, in 3 years, I want to be living by the beach, so this is my plan for this business. In 4 years, I want us to have 27 locations, and this is my plan for the business. And the more honest and open you can be upfront when it comes to this, the better that you'll be, the better your relationship will be, the better your business will be, the better everything else will flow from there. So I hope that you enjoyed this episode. I hope that it makes sense. And I hope that it's, if you don't have a signed agreement with your business partner or someone who you're doing a joint venture with, I hope this is sort of the kick in the pants that you needed to get going. I'm going to include a link for this episode for a free consultation, safe space. Let's chat. I want to support you. I want to see you fully protected. And whatever it is that you do, make sure you're working with a lawyer who loves you. Thanks so much for listening.